Good afternoon. Thank you so much for joining our webinar today, Training the Technique, Advanced ERISA Compliance. My name is Christine and I will be your moderator today. ERISA attorney Larry Grudzien is our presenter. This is a topic we've seen a lot of questions on. If you missed something, don't worry. We'll be emailing you a recording and the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. We'll stop at the end for questions. Just type your question in the box below and I'll read it out loud for you. Our next webinar will be on Tuesday, May 15th at 1 p.m. Central Time on COBRA pitfalls, common mistakes, and how to avoid them. All right, take it away, Larry.
I appreciate it. Thank you, Christine. What I'm going to do is I will bring Christine back a couple times just to see if there's any questions. So please don't wait to the end. If I cover something that you have a question on, please, as we indicated, there's a question tab on your dashboard. If you look to the right, look down and just type in your question. And now, this seminar is pretty lengthy. I'm going to try to go through some slides very quickly. Others I'm going to concentrate on. But you'll be given a copy of the slides. I'm trying to cover all aspects of ERISA, and there's certain areas that I want to concentrate on only because I've gotten a ton of questions. Even though ERISA has been around, it was passed in '74, and it was effective in '76. There's still a lot of questions about when ERISA applies, how it applies, what do we have to do, and I'm going to concentrate on basically administering a health and welfare plan and how it affects your administration. To be careful because there's a lot of nooks and crannies in ERISA. So first of all, who must comply? And this is a very common question I get, every private sector employer. That means that corporations, partnerships, sole proprietorships. And what's interesting and what a lot of people don't understand is that if you're an owner and you hire one employee, ERISA does apply. So there's a misnomer here of two things. One, you have to be 100 or more for ERISA applied. That's not true. Some people think it doesn't apply to not-for-profits. It does. What it doesn't apply to is governmental employers and church plans are exempt from the application of ERISA. Now, those entities can choose to comply with certain sections of ERISA. They can pick and choose what they want to comply with. But again, not-for-profit, if you're a private not-for-profit, all these different rules will apply to you, and you have to be very careful to make sure that you comply with the written requirements, but also the disclosure requirements of ERISA. So what plans must comply? Well, and again, most benefits that you offer employees will have to comply with ERISA if it's an employee welfare plan. Okay, so what is an employee welfare plan? And this is defined under ERISA. There must be a planned funded program established or maintained by the employer and for the purpose of specified benefits to participants under and beneficiaries. So it's got to be a plan that's established by the employer. And there are a number of exceptions and safe harbors that I'll be explaining. So not every benefit that an employer offers will be covered, but most will be. And I'll be talking about the exceptions to this. And when I'm saying that ERISA applies, it means the written plan requirements, the disclosure requirements, all apply in this situation if you have what's considered to be an ERISA welfare plan. So in determining whether there's a planned funded program, all right, we look at these things, the intended benefits, the class of beneficiaries, the source of financing, and the procedures for receiving benefits. There's a very famous case, Fort Halifax Packing, that you see in the bottom there, provides that a plan exists only when there is a commitment to pay benefits systematically, including an ongoing administration responsibility or scheme in determining eligibility and calculate benefits. Many times, employers will offer a short-term benefit, such as severance, a one-time deal. And that's what this case that you see there on the slide indicates. This was a case where it was a short-term severance program, and they said, well, because it's short-term, because you're only offering it once, there's no ongoing administration, then ERISA doesn't apply. Now, if it's determined there's a planned funder program, all right, some arrangements do not qualify. So it's easy to satisfy the basic fund planned funder program test. For example, if an employer offered a one-time lump sum severance benefit, that's what that case is, there is no ongoing administration. Now, if it's determined that you have a planned funder program, a written document is needed to create a plan or fund. And what's interesting about this, even though ERISA indicates that you have to have everything in writing, ERISA doesn't really specify and doesn't really indicate in detail what that writing has to contain. And what courts have found in the past is that they've actually established a plan that's sponsored by the employer through emails, through letters, through various things. So the court will stretch it just to make sure that a fund, a plan, or program has been established. So when necessary elements of a plan can be ascertained, however, maintaining a plan without a written document is a violation of ERISA. So please, it's in your best interest that if you're going to offer a benefit that it's subject to ERISA, make sure all the plan terms are written down. So, and again, employer doesn't need to do much to establish a plan, and it becomes more of a problem when there's a self-funded plan, because you don't have an insurance contract to rely on. But again, just because you have an insured arrangement doesn't mean that satisfies all the requirements of being an actual plan document. Many insurance contracts don't contain all the elements of being a plan. But again, you're 70 or 80% there. So individual insurance policies may create an ERISA plan, depending on, again, all the surrounding circumstances and where we have the intent for the employer to establish a plan. Now, does the plan provide a type of benefit listed under ERISA? And under ERISA, these particular types of plans can be deemed to be an ERISA benefit. Medical, surgical, and hospital care benefits, benefits in the event of sickness, illness, disability, death, or unemployment, vacation benefits, apprentice and other training benefits, daycare centers, scholarship funds, prepaid legal holiday and severance pay benefits can be, in housing assistance can be ERISA benefits if it's employer provided. Are the plan benefits provided to participants and beneficiaries? Who are participants and beneficiaries? They can be current employees. Beneficiaries, a person designates by the participant, that's usually a spouse or children. And also it can include retired employees, and COBRA qualified beneficiaries can be entitled to benefits, and those are considered to be participants or beneficiaries. So plans covering self-employed individual partners are not considered an ERISA benefit. It has to cover common law employees. Can plans covering one employee or former employee be considered an ERISA benefit? Yes, if it's a non-owner or non-executive. Can be a common law employee, can be considered to be an ERISA plan. So again, employers with just a few employees also have to comply with ERISA. Now, there are a number of different statutory and regulatory exceptions. So again, governments, church, and other statutory exceptions. Such programs as workers' comp, unemployment benefits, and disability benefits can be excluded from being ERISA benefits. That's called a payroll practice. So again, it depends how you set them up. So there's a payroll practice exception. This includes any payment of wages, overtime pay, shift premiums, holiday or weekend benefits, unfunded sick pay or income replacement benefits, and vacation, holiday, jury duty, and similar pay. So again, you could have a disability program that that is self-insured that would be considered to be a payroll practice not subject to ERISA. What does that mean? That means it's treated just like compensation. None of the ERISA requirements apply. The plan document requirement doesn't apply. The disclosure requirements apply. And there's no fiduciaries. There's no claims procedures. So this is something, again, that employers look at and say, what is my advantage of making my disability benefit a payroll practice? But there's also some benefits in having something subject to ERISA. Yes, you have to go through 5500s if you have so many participants. Yes, you have to have disclosures and plan documents. But also, if an employee wants to sue you, the only remedy is getting your benefits. Any other damages does not apply, and the employee has to sue if the benefit is subject to ERISA in federal court. If it's a payroll practice and ERISA doesn't apply, then the employee can sue in local court, state court, and depending on the circumstances could get other damages, not just their benefits. So there's pros and cons in this situation and looking at these statutory and regulatory exceptions. Now, one of the biggest exceptions is described in this slide right here. This is called the voluntary employee pay all exception. And many times, and this has become very common over the last probably 5 to 10 years, more and more of the benefits that the employer provides have no employer contributions. It's all employee paid. Many times employers will offer dental, vision, life insurance policies that are completely employer paid. So as this says, the employer allows an insurance company to sell voluntary policies to interested employees who pay the full cost of coverage. It permits employees to pay their premiums through payroll deductions, but the employer may not make any contribution towards the coverage, and the insurer may not pay the employer for being allowed in the workplace. Now, the kicker in this, and this is where the exception narrows. The employer may not endorse the program. This element is the key element in treating the program as an ERISA benefit. What makes up an endorsement? If the employer selects the insurers, negotiates terms, linking the plan coverage to employee status, using the employer's name, recommending the plan to employees, doing more than permitted payroll deduction. Also, another kicker here is if you pay for these premiums through a cafeteria plan, that is seen as one element of the employer endorsement. So if you want this voluntary employee pay all exception to apply, don't put the contributions through a cafeteria plan. That is seen by the IRS and DOL as being an endorsement. So the examples, what benefits are subject? Cafeteria plan. Generally, the pre-tax contributions under cafeteria plan are not ERISA benefits. The dependent care is not an ERISA benefit, but the health FSA is an ERISA benefit. It's considered to be an ERISA medical plan. Insured major medical, yes. HMOs, yes. Dental coverage, yes. DCAP, no. AD&D coverage, yes. Group term life insurance, yes. Long-term disability, yes. Paid time off, no, it's a payroll practice. Employee assistance, no. Educational assistance, no. Short-term disability may be a payroll practice. It's up to the employer. They can choose to have it a payroll practice or an ERISA benefit, and depending on the circumstances, whether it's insured or self-insured. Severance coverage, yes. And voluntary insurance, no, but you have to adhere to all the requirements of the voluntary exception. So these are important terms. If you're going to talk about ERISA, these are important terms you have to really understand. An ERISA plan, this is an ERISA plan. Benefits are provided by the employer, and it provides benefits that are specified under ERISA. And when you have an ERISA plan, then all the different requirements we're going to be talking about apply. Plan sponsor. Plan sponsor is an important term because that's the entity that actually has the power to amend and terminate the plan. So the plan sponsor is extremely important. ERISA plan administrator, that can be the employer, it can be an individual, it can be an insurance company. An ERISA plan administrator is extremely important because that is the fiduciary that determines claims and eligibility. So by being a plan administrator, you have complete fiduciary responsibility, which means you have discretionary authority under ERISA. Participants and beneficiaries, these are, again, employees, spouses, and dependents. Dependents, whoever is eligible to participate under the plan. One thing you have to do is name what's called a named fiduciary. These are people that, because of their duties, and you have to name it in the plan document. And many times it's the employer, it could be the plan administrator, or could be a third-party administrator if they have discretion under the plan. But there's also different ERISA fiduciaries. It could be corporate officers. Anyone who has discretion under the plan could be what's called a functional fiduciary. In other words, they're not named in the plan, but because of their duties, could be deemed to be a fiduciary, deemed to have discretion. So again, it's extremely important. And what's important here is that if corporate officers are deemed to have discretion under ERISA, then they can be held personally liable for any losses, any lost benefits that participants don't receive. They could be held liable for those benefits. And a third-party administrator, more and more, that's a TPA, for example, could or could not be a fiduciary. It's dependent on whether they have discretion under the plan. And discretion is, do they have ultimate authority to determine claims? Do all appeals go to them last? And the employer has no discretion in determining appeals. In that situation, a third-party administrator could be a fiduciary in that circumstance. But that's, again, an outside party that's assisting the employer in administering the plan. So key ERISA requirements. All ERISA benefits have to have a plan document. It's required in ERISA that the plan terms be followed. Strict fiduciary standards must be filed. In other words, anybody has discretion under the law has a strict duty to make sure that the benefits promised will be delivered. A fidelity bond must be purchased to cover any person who handles plan funds. And again, that's very rare under welfare benefits. It's more common under 401k. But if your plan is funded, and I'll be talking about what that means, under ERISA, if you have set aside benefits or assets in the plan name, they need to be held in trust. A summary plan description must be furnished automatically to plan participants. Summary of material modifications must be furnished automatically to participants when the plan is amended. Remember, the plan, one of the requirements in ERISA is the ongoing commitment of the employer to make sure that the plan is, any changes are communicated to the employees. And copies of certain plan documents must be furnished to participants and beneficiaries upon written request. So what that means is you don't have to automatically give a copy of the plan document to participants, but if they ask, you have 30 days to actually deliver that. Form 5500 must be filed annually for each plan. And again, if the plan is unfunded, you have to have 100 employee participants in order to file a 5500. A summary annual report summarizing the 5500 must be furnished automatically to plan participants. Again, only you have to file a 5500. Claim procedures must be established and carefully followed. Plan assets, including participant contributions, may be used only to pay plan benefits and reasonable administrative expenses. And this is, again, You have to watch what you spend under the plan because, especially if you have participant contributions and you charge for any expenses, you have to be absolutely sure that those expenses are reasonable. For a few welfare plans, if you have plan assets, those plan assets must be held in trust. So if you have a situation where you have a self-funded plan and you set money aside in the employer's name, you don't set it aside in the plan's name, that's not being funded. Funded means you actually set aside a bank account or savings account or something in the plan's name. And again, group health plans must conform to applicable mandates such as COBRA and HIPAA. So let's look at the plan document requirements. Again, ERISA does not require benefits to be provided and applies only after the employer undertakes to provide benefits. Plan design decisions are generally not subject to fiduciary rules. And again, which is interesting, ERISA does not impose, imposes just few requirements in plan design. So again, a plan must be established and maintained through a written document. ERISA Section 402 requires every welfare plan to be established and maintained in a written document. That written instrument does the following. It puts the employees on notice of what they're going to be provided, and it gives the plan administrator guidelines to exactly what benefits are going to be provided. And that's going to be important because if you start varying benefits according to each employee, it's a violation of ERISA. So again, ERISA does not provide specific format or content. Many times what you do in order to establish a ERISA plan document, you may do a wrap plan. You wrap it around the insured benefits to provide all the ERISA requirement. So again, the purpose of a wrap document is to fulfill any missing ERISA requirements. So what are the consequences of failure to have a plan document? There's no specific penalties. You have the inability to respond to written participant requests. Benefit lawsuits may be based on past practice and similar evidence. Less favorable standard to review. Limited ability to amend and terminate. And it puts the plan fiduciaries in a pickle because of the fact that they have a hard time following the plan document if there's no plan document in existence. So, and again, ERISA does not dictate what constitutes a plan document. The plan document compliance issues for insured plans. The insurance contract does not contain all the elements that an ERISA plan should have. Again, you could bundle it, provide for a wrap plan, and a single document could actually serve as both plan document and SPD. It is possible. So again, when in doubt, use a wrap to comply with all the different ERISA plan document requirements. These are some of the ERISA required plan provisions. Name a named fiduciary. Procedures for allocation of responsibility. Who has responsibility to amend and terminate the plan? How are the benefits going to be funded through employer contributions, employee contributions? How payments are to be made? Any claims procedures, amendment procedures, distribution of assets if there are any on plan termination, and then all the different required provisions for group health plans, COBRA, HIPAA, minimum stays for childbirth. All the different mandates have to be included, especially in a plan document for medical plans. Now again, most of these terms are in an insurance contract, but again, not all of them are there. ERISA also permits a number of arrangements, including fiduciaries, to be addressed in the plan document. Other important terms: permission to use plan assets to pay plan administrative expenses, incorporating provisions that apply in the SPD, including eligibility and benefits promise. Exceptions and limitations can result in loss or denial of benefits. A provision required by other laws, including family and medical leave, which may or may not be an insurance contract, and how the plan will be administered. Naming the plan administrator, that may not be in your insurance contract. General business elements, governing state law, no contract of employment, no guarantee of tax consequences. Discretionary language for court review, subrogation and coordination of benefits, language regarding exclusion of independent contractors, and whether there's an assignment of benefits is permitted. Some of these are in your insurance contract, but not all of these are in your, and so that's the purpose behind our wrap document, to make sure all these elements are included in your ERISA benefits. Now, one of the most important elements of ERISA is specifying the duties and responsibilities of those individuals that have fiduciary duty under the plan. What does that mean? It means having discretion of the plan, having discretion on what benefits are provided, who is eligible, when is the plan going to be amended. All these elements, again, it could be corporate officers. So ERISA's fiduciary rules are distinguished from any other rules of behavior. The rules incorporate a broad functional definition of a term fiduciary. It's basically anyone who has discretionary authority under the plan. The standard of behavior expected is very high. It's almost like a trustee under a trust. Broadly defined fiduciary responsibilities apply in every act taken by fiduciary. Certain specified transactions between an ERISA plan and those acting a fiduciary, that's called a prohibited transaction, are prohibited. In other words, if you have discretion under the plan, what that is trying to say in layman's language, you cannot take advantage of the plan and make money off of the plan. And again, ERISA fiduciaries who breach their duties can be held personally liable for damages to the ERISA plan and for the DOL penalties imposed in connection with fiduciary breaches. That means if corporate officers have discretion under the plan, they could be held personally liable if benefits that are promised weren't delivered. And sometimes I see this in a situation where somebody promises a medical benefit, they don't pay the premium, the benefits are not provided, and all of a sudden the plan participants and the DOL go after the employer and the corporate officers. So again, automatic fiduciaries are the named fiduciaries, plan administrators, trustees, and others. And again, some of these have to be named. The named fiduciary, of course, has to be indicated in the plan document. And again, that designation may not be in an insurance contract. Functional fiduciaries, these are individuals become fiduciaries to the extent they have discretionary authority or discretionary control regarding the management of the plan, have authority and control respecting the management and disposition of plan assets, render investment advice, or most important, have discretionary authority or discretionary responsibility in the administration of the plan. So if your corporate officers, for example, decide and work with the broker in deciding what insurance company will be providing benefits, they are a fiduciary, and that's because they have discretionary authority or responsibility in administration of the plan. Now, providing benefits in an insured plan, the insurance company is a fiduciary in providing the benefits promised. But again, the corporate officers have the responsibility to make sure the insurance company provides those benefits. So the duty and integrity imposed on fiduciaries have been the highest, as I indicated before. And again, it is comparing a trustee under a trust. Their duty is to make sure that those benefits that are promised are provided to the participants and dependents. So this is what a fiduciary has to do. Act solely on the best interest of plan participants, use plan assets for the exclusive purpose of paying benefits or reasonable expenses. And again, even if your plan is not funded, it's self-insured and it's not funded, if you have employee contributions, that's considered to be plan assets. And you use employee contributions to pay part of the plan expenses, this is where it comes in. Those expenses, you have to make sure those expenses are reasonable. To act with skill, care, prudence, and diligence that the prudent person in similar circumstances would use. Diversify plan and plan investments, and to act in accordance with the documents governing the plan, which means you have to make sure whatever benefits are promised are provided to participants and their dependents. And again, as I indicated before, ERISA Section 406 prohibits certain listed transactions unless there's a statutory and regulatory exception. Such transactions involve a plan and a party of interest and a plan fiduciary. And basically, the best way to summarize that is there can't be self-dealing. If you're a fiduciary and you have discretion under the plan, you cannot make profit under the plan. And that's extremely important. So here are the fiduciaries prohibited from causing the plan to engage in a transaction the fiduciary knows or should have known that the transaction that constitutes a direct or indirect sale or exchange or leasing of any property between the plan and the party of interest. Party in interest is the fiduciary or plan official. Lending money or other extensions of credit between the plan and the party in interest, furnishing goods, services, or facilities between the plan and the party of interest, transfer or use of by or for the benefit of party interest any assets of the plan, and acquisition on behalf of the plan of any employer security or real estate. So again, you have to be very careful if you're going to deal with plan assets, and especially in this situation, employee contributions, and paying for those expenses that are caused by an individual who's a party in interest, which is an individual who is a fiduciary. So again, you cannot deal with the asset. You have to deal with the assets of the plan in the fiduciary's own interest. You can't do that, self-dealing. Act in any transaction involving the plan on behalf of a party in interest or adverse, and receiving any consideration for his or her personal account from any party dealing with such plan. So again, if you're providing services to the plan and you're a fiduciary, you've got to be real careful. And again, as I indicated before, what this slide indicates, if you're deemed that you've breached your fiduciary duty, as I indicated before, you as a fiduciary are held personally liable for any losses caused to the plan, personal liability restored to the plan, any profits the fiduciary made through the use of plan assets, and any equitable or remedial relief, which means providing benefits. So again, warn your corporate officers that they have these responsibility if they have discretion under the plan. And again, if you have plan assets, then you have to have a bond. That's what that describes. Also, if there's any fiduciary breaches, again, there's called a voluntary fiduciary compliance program. It covers 18 different fiduciary breaches. To be eligible to plan an employer must not be under any investigation. What you do is you correct the situation, restore the plan to where it was. The correction is documented. You file an application, and then the DOL promises not to go after you. Let's stop for a second. Are there any questions?
It does look like we've received one question, Larry. It says, if you provide a rep, what if you have a plan? Example, life has 102 participants, dental has 70. Because the dental is in the rep, do you have to file the 5,500 on the dental?
Yes. It's treated as one plan of any benefit. That's a disadvantage of there. If any one benefit has over 100, then you have to file for the whole wrap.
Okay.
But again, what's important is if you don't do a wrap, you could have a separate 5,500 requirement for each separate benefit that you provide to your employees.
Okay.
So I mean, that's extremely important. I'll be talking about that in a couple minutes. So that's important. So that's what a wrap, one of the purposes of a wrap. And that's how I first got involved in wrap, because employers were starting to have benefits that were approaching 100 participants. And they would come and say, well, you know, we have medical or we have dental that's approaching 100. can we do a 5,500? Then I would say, well, where are your other benefits? And they were close to 100. I said, why don't we just do a wrap now and get a Schedule A? And again, what's important here is that the policy years for these benefits don't have to be the same. They can be different policy years. You just include a Schedule A for the policy year that ends in the plan year. So you pick an ERISA plan year. And
Okay.
and what I do in that situation is, if you look at the ACA, the Affordable Care Act, all the changes are based on an ERISA plan year. So what I try to do is when I design a wrap plan, I make it so it replicates the plan year of the medical plan, because the ACA changes are all based on the ERISA plan year. So the benefits all the benefits could have different policy years. And I just include the Schedule A for the policy year that ends in the plan year. That's what I do. Okay.
Okay. Sure. Yep. That makes sense. I hope that helped answer that question. And then that was it for now.
Okay. Now let's look at the another important requirement of ERISA is disclosure requirements. There's a number of different disclosure requirements, and this is one area I think that is of special interest to the DOL auditors. If you get audited by the DOL, this is one of the things they're really particular about. Did you provide all the disclosures that are required under ERISA? So let's look at this. And many times when you go through a DOL audit and you haven't done everything perfectly, 9 times out of 10, the DOL will say, okay, here's what you have to do, fix it. And then they will come back and revisit you within a period of time, 60 or 90 days, to see if you fixed everything. So just because you're not doing everything perfectly doesn't mean you're going to be penalized. But again, it's embarrassing to your corporate offices, to your employer, if you're not doing everything perfectly. So try to do as much as you can to make sure your employees are notified of all the different rules. So this is a summary of the disclosure requirements. There's a summary plan description. There has to be one for each benefit. Summary material modifications, which basically, if you have amended the plan document, you have a choice of either doing a full new summary plan description or a summary of material modifications, which is basically amends the summary plan description and just describes those changes. Summary annual reports, which summarizes the information on the 5500. There's summary of benefits and coverage. There's providing copies of documents on written request and making documents available at a principal office. Now, as an employer, what you have to do, and the law says you have to provide a summary plan description, a summary of material modifications, a summary annual report, and a summary of benefits and coverage. You have to provide it. You have to make sure the employees get it. It can be hand delivered, it can be mailed, or it can be done electronically through email or posting. I'll be talking about that. But again, you can't say to the employees, if you want one, tell us. No, that's not what the law says. The law says that these items must be provided. So now, providing copies of documents on a written request. These are the plan document, not the summary plan description. So the employees can ask for a copy of the plan document. So let's look at this. So what plans must comply? Almost every employee benefit plan must comply under ERISA. There's no small employer exception. So if you have one employee, you have to meet these disclosure requirements. Are there any plans at exception? Exception for employer-provided daycare centers, welfare plans for selected employees, and cafeteria plans. Now, again, the section of the cafeteria plan that is not an ERISA plan are your POP section and dependent care. Your health FSA is an ERISA medical plan. Again, as I indicated there, there's no small plan exception. Who is responsible for complying? Whoever is designated as the plan administrator. It can be the employer, it can be the head of HR, it can be a named individual. But they are responsible to making sure that participants get a copy, are furnished a copy of the SPD and SMM. So in general, it's covered participants, not beneficiaries, have to get it. But there are exceptions. So a COBRA qualified beneficiary has to get a copy of the SPD. A qualified medical child support order alternative recipient must get it. Spouse or dependent of a deceased participant, and representatives and guardians of incapacitated persons. For the SBC, generally must be distributed to all applicants, policyholders, and enrollees of your benefits. So summary plan description for any new employee must be provided within 90 days when they first become eligible. If it's a new plan, it must be provided within 120 days. And then an updated SPD must be provided every 5 to 10 years, depending on how many changes there were to the plan. So again, as I indicated, it must be provided. It must be furnished in a way reasonably calculated to ensure actual receipt of the material. So it can be hand delivered, it can be furnished by mail, or it can be done by electronic means. What does that mean? It can be emailed or posted. Now, this is tricky. If not all your participants have access to a computer at work, then you have to get their permission to provide it electronically, or you must give them a hard copy. If you're going to post it on a website, you must give them written indication of where that SPD is sitting. So like a postcard or a letter or something. So general format and style, it must be designed so the average individual can read it. And it must be accurate and comprehensive and inform plan participants and beneficiaries of their rights and obligations of the plan. It must be written in a manner understandable to the average plan participant. It can't be misleading. And you must describe any exceptions, limitations, reductions, and other restrictions of plan benefits, which means that many highlights brochures don't cut it. All these things must be provided to the employee, and that's the source of the DOR regulation. So items that must be included in the welfare SPD. Plan identifying information, description of plan eligibility requirements, description of plan benefits, statement clearly identifying circumstances that may result in loss or denial of benefits, description of plan amendment and termination provisions, description of any subrogation provisions, and information regarding plan contributions and funding. And again, some of this information is not included in the insurance contract. Other items, information regarding claims procedures, model statement of ERISA rights, prominent offer of assistance in non-English language, explanation of plan's policy towards recovery of overpaid benefits, explanation of the allocation for insurer refunds or similar payments, and discretionary authority to interpret the plan. Who is responsible for doing that? If you have a group health plan, these additional items must be included: a detailed description of group health plan provisions, description of the role of the health insurers, description of group health plan claims procedures, discounts, group health plan provider incentives, information about COBRA, and disclosures of other federal mandates must be included in the SPD. How about the SMM? The SMM must describe the amendment to the plan. You must, again, within 210 days after the end of the plan year, you must describe the change. In regard to health plans, it's 60 days if the change is a material reduction. Now, please remember, if you're making a change in the middle of the plan year, it's not required under the SPD or their SMM, but it is required for the SBC that you must provide that change 60 days before the change is effective if it's made in the middle of the plan year. I'll be talking about that in a second. If there's any conflicts between the SPD and SMM, the plan document insurance contract, the SPD will generally control. And again, many times you'll see disclosures. Some courts have indicated they are control, others do not. So yeah, it depends on what circuit you're in. Consequences of furnishing SPDs or SMMs that otherwise violate. Some courts accept substantial compliance. Possible liability for additional benefits if it's unclear. Possible fiduciary breach liability. And failure to comply with understandable and other format changes. So there's no specific civil penalties if your SPDs don't comply. But there could be possible criminal penalties for willful failures, $100,000 or prison for 10 years. But again, it's got to be egregious. I've never seen anyone do this. And written request penalties are $110 a day. Now, other disclosures, if an employee requests a copy of additional copies of SPDs or plan documents, they have a right to receive it. You must provide it within 30 days of the request. If there's a failure to provide, then the penalty could be as high as $110 a day. But in order to collect, what they must do is file suit in federal court. So again, employees have a right to see various documents, see the that support the benefits. So please, if you get a request, honor it. Also, if the information is too much, documents can be available for inspection at a principal office of the employer within 10 days of the request. And then summary of annual reports. In that situation, it summarizes the information on the 5500. It must be given out, I think, within 9 months after filing the 5500. And all it does is summarize the information. There is model language in the regulations that give you the language that actually supports it. But if you don't have to file a 5500, you don't have to provide it. Again, the summary of benefits and coverage, this is something separate than the SPD. They must provide it either through paper or electronic means. SPCs are limited to more than 4 double-sided pages. It can be provided electronically. And then the plan administrator is responsible for providing the SPC. Generally, when is it due? It's generally due at open enrollment. So in general, SPC are required to be provided as part of any written application materials and are distributed to by the plan or issuer on enrollment. The plan, if the plan does not distribute written application materials for the enrollment, the SPC must be distributed no later than the first date the plan is actually eligible to enroll. And then again, you have a requirement that you have to provide it at every open enrollment. So healthcare insurers and group health plans are required to provide automatically to an individual prior to enrolling, within 60 days prior to the date of any significant change, or within 7 days when the individuals require or requested. Okay, let's skip that. I'm going to skip a couple because I think everybody knows this. Now, violations, the SPC, if there's a violation, a person or beneficiary not receiving a SPC, it's a civil penalty of $110 a day. An excise tax of $100 a day per affected individuals. For violations of contact and form, the penalties can be over $1,000. Now, one thing is requirement. One thing is, I think is important, is the fact that if you have a change in the middle of the plan year, what is required is you have to basically give notice 6 days before the effective date of the change, only if the change is made during the plan year. So if you can change contributions or benefits, again, there's a 60-day advance notice requirement. Reporting requirements. Now, again, the plan administrator for each separate ERISA plan must report a specified plan information annually to the IRS. to the DOL. There are exceptions for small plans. If you're a small unfunded plan, and we're talking about at the beginning of the year, if you have less than 100 covered participants, which means employees, you don't have to file a 5500. So if you're insured or unfunded, you have under 100 participants, then you don't have to file, and it's determined at the beginning of the plan year. But again, that's determined by each separate ERISA benefit. And the only way that you can file one 5500 for all your benefits is by adopting a wrap plan. So the penalties to apply for late or unfiled 5500s, the IRS may, the DOL may assess a civil penalty of $2,063. And the penalties are cumulative against each Form 5500 not filed, and there's no statute of limitations. So if you have not filed a 5500, please, there's a delinquent filer program, which I will describe in a few minutes. Here it is. So delinquent filer voluntary compliance program. In this situation, if you have any unfiled 5500s, you can go then file under this program. The penalty goes from goes from over $2,000 a day down to $10 a day. And for all years, the most you can have to file for large plans is $4,000. I've had situations where I have filed returns for over a 10-year period. The penalties would be in the hundreds of thousands of dollars. The employer paid all the delinquent under this program 5500s and only were subject to a $4,000 penalty, so it's a deal. How many forms are required? One Form 5500 may be used for multiple ERISA benefits under a single plan. But again, it all depends how you communicate and how you maintain your ERISA benefits. Without a wrap plan, you may have to file multiple 5500s because it's dependent on how it's communicated to the employees. So again, a 5500 has to be filed by the end of the 7th month after the end of the plan year unless it's extended. You can get an automatic extension by filing a 2.5-month extension by filing Form 5558. What do you have to file? You have to file a Form 5500. For each your insured benefits, you have to get a Schedule A from the insurer. If you have any plan assets or the plan pays expenses, you have to file a Schedule A. You know, if you're funded, you have assets, you have to have financial schedules and accountant's opinion if funded. And remember, all 5500s for a number of years have to be filed electronically. You can't file on paper. Also, there are claims procedures. ERISA plans must establish and maintain procedures under which benefits are requested by plan participants. What if you don't follow the claims procedures or the insurance company doesn't follow it? Claimants can skip procedures and go directly to court. So basic steps for claim procedures: claims for benefits and claimant and authorized representatives, benefit determinations by the plan, appeal by the claimant and authorized representative, and the determination or review. So here what you have and what ERISA requires, there has to be a determination of the claim. If there is a denial, then there's at least one appeal process, and the individual determining the claim or the appeal must be different than the individual that issued the original denial. Procedures can vary depending on the type of claim involved. Claim must be in writing. Claim must be with certain time limits, either health, disability, or others. These are the various claims for various types of urgent care, pre-service claims or post-service claims. And this will be provided, if you're insured, it will be provided in your insurance contract. If you're self-insured, all these have to be indicated. And this is when initial claims have to be processed. So all adverse determinations must be in writing, must be understandable, and indicate the specific reasons for denial, description of any additional benefits, and a description of the appeals process. And a statement that a copy of the initial rules and guidelines relied on denying the claim must be obtained, and the statement that the written explanation of any specific scientific or clinical judgment. The appeals process, an individual must be given 180 days to appeal. And if the individual doesn't appeal, they lose the right to file further claims. So if they want to keep it alive, they must be advised they have to file the claim within 180 days. Once the appeal is filed, the claimant must receive a full and fair review by the named fiduciary. And again, the named fiduciary has to be different than the individual that denied the original claim. And claimants must be permitted to submit written comments and access documents. It must be in writing, contain certain information, and the adverse determinations must provide the reasons why of denial, a description of any additional information, and a statement of the claimant's rights to obtain relevant documents and other information. A description of any additional required of voluntary appeals. And many plans do have more than one appeal. But again, under ERISA, one appeal is all that's required. Group health plans and disability claims, a statement that a copy of the internal rules and guidelines relied on denying the claim may be obtained. And again, for appeals, this is when it has to be decided. Also remember, for health plans, there's now under ACA, there's external appeals provisions which have to be included in the plan documents. Now, what happens if there's non-compliance? There's ERISA penalties, employee confusion, participant lawsuits, denied benefits, and bad press. Record keeping. This is a very common question I get. How long do I have to keep my records for my ERISA plan? So specified record keeping is required, requires retention of records sufficient to document information that is required for filing Form 5500. And basically what it indicates, you must retain the records to document information on Form 5500 for a period of not less than 6 years after it was filed. So I advise my clients to keep their that information, any claims information or any information about the ERISA plan for at least 7 years. For at least 7 years. Who must maintain records? Those persons who are reporting or certification requirements. So again, it could apply to the plan administrator, insurer, TPA, and CPA. And these records apply to even those who don't have to file 5500s. What records must maintain? A record significant to verify the information on Form 5500. Records subject to the rules are defined broadly, include claims record. Summaries or recaps of actual records are not sufficient, and it can be kept electronically. Christina, are there any questions?
Hi. Yes, we do have 3 questions. Okay, so the first one is a follow-up question to the previous one. It says, do you need to include a Schedule A for the dental plan or just declare code for D on the Form 5500?
If you have a RAB plan, you would have to include the Schedule A's for all benefits included in the RAB plan.
Okay, got it. Thank you. And then next question, can the SBC be emailed to an employee's personal email address?
I think it's possible, but again, you have to make sure they receive it.
Sure.
That's going to be interesting to prove that that person actually received it.
Got it. Okay. And then the last question for today is, are there situations where Form 5500 must be filed besides them having 100 or more participants on the plan?
Yes. Two situations: if the benefit is funded, which means there's assets set aside for the remember, for under 100, it's insured or you're unfunded, which means you're a self-insured plan, you don't have plan assets. And many small self-insured plans don't have plan assets. But the other situation, which is important, is there could be, if you're part of what's called a MIWA, multiple employer welfare arrangement, and you include employers that have less than 25% of common ownership, then that 100 or more requirement does not apply, and you have to file. So if you decided that you're going to join with other employers and you don't have at least 25% common ownership, then you have to file a 5500.
Okay, that sounds great. Well, that's all the questions we have today.
If you have any questions, that's my contact information right there. So again, thank you very much for your time. Appreciate it, and we'll see you next month.
Okay, see you then. Thank you.
Bye-bye.
Bye-bye.